Hello everyone, welcome to Mains 2019 question analysis. Today we shall be taking up this particular question which appeared in GS paper 2. In this analysis, we shall try to understand about this particular question, the requirement of this particular question, as well as the approach with respect to answer writing process. So let us undertake this particular question asked in GS paper 2. The question was, on what ground a people's representative can be disqualified under the Representation of Peoples Act of 1951? So three aspects becomes important with respect to this particular statement of this question. First is people's representative, second is his or her disqualification, and this disqualification under the Representation of Peoples Act of 1951. So the first part of this question is asking about grounds of disqualification with respect to a people's representative who can be a MP or a member of legislative assembly. The second part of the question says that also mention the remedies available to such person against his disqualification. So the second aspect of this question pertains to the remedies available to such person with respect to his or her disqualification under Representation of Peoples Act of 1951. Now as you can go through the syllabus, it comes under GS paper 2 specifically with respect to important provision of Indian Constitution as well as salient features of Representation of Peoples Act. Now this particular question was asked by UPSC because a similar news appeared around the month of August 2018. Now the news was with respect to disqualification of the Chief Minister of Sikkim. And this topic of disqualification of CM of Sikkim was covered in Daily News Simplified in the month of August as well as October. Now this question has been asked in a very clear manner as it is talking about grounds of disqualification and also the remedies available to such persons. So both grounds of disqualification as well as the remedies can be a part of your body with respect to this particular answer. Now here you can introduce your answer by straight away mentioning about Article 327 of the Indian Constitution, which empowers the Parliament to make a law whereby it empowers the Election Commission with respect to disqualification of members of Parliament as well as members of state legislatures. And hence, accordingly, the Parliament has enacted the Representation of People Act of 1951. And after mentioning about this, you can straight away come to the grounds of disqualification as provided under Representation of People Act of 1951 and also remedies available with respect to such disqualification. And here you can conclude your answer by stating that since disqualification as per the present law of Representation of People Act 1951 triggers only after conviction, here the Government of India can think about implementing the 244th Law Commission report with respect to decriminalization of politics. Here you can state that the government can think forward to make a law whereby disqualification can initiate at the stage of framing of charges with adequate legal safeguards. So these can be said to be the ingredients of your answer. So before understanding the ingredients which needs to be mentioned or written with respect to grounds of disqualification as well as remedies available, first of all, let us go through the DNS which occurred in August whereby it mentioned about the disqualification of CM of Sikkim as well as the powers of Election Commission and also go through how this topic was covered in the Focus magazine. Now as you can see, this particular topic with respect to disqualification of Chief Minister of Sikkim appeared in the newspaper on 18th August 2019 and it was duly covered in the DNS video whereby we not only mentioned with respect to section 8 as well as section 8A but also with respect to section 11 of Representation of People Act 1951 specifically where it empowers the Election Commission of India to remove disqualification or reduce the duration of disqualification as provided under the Representation of People Act of 1951. So we mentioned that the Election Commission under Section 11 of Representation of People Act 1951 has the power either to reduce the duration of disqualification or to completely remove such disqualification. However, the Election Commission has to give reasons to be recorded in writing. Further, when this story developed, we also covered in the month of September, and this was covered by Baswa sir. As you can see, he covered different important aspects with respect to Article 324 as well as 329 of the Indian Constitution with respect to conduct of elections as well as important provisions of Representation of People Act 1951, whereby he mentioned clearly about Section 8 as well as Section 123, which list down a number of corrupt practices which also becomes a grounds for disqualification. So these different corrupt practices under Section 23 of Representation of People Act 1951 were bribery, undue influence, appeal by the candidate on grounds of religion, race, caste, community or language, use of national symbols such as flag emblem for contesting elections, promotion of enmity or hatred between different classes of citizens of India, propagation of sati or its glorification, as well as getting assistance from any gazetted officer with respect to enhancing the prospects during a election. Further, Baswa sir also mentioned about Section 11, which empowers the Election Commission to remove the disqualification or reduce the term of disqualification as already mentioned. Now, again, this particular topic was covered in the June 2019 edition of Focus magazine, specifically with respect to Section 123 of Representation of People Act 1951, which lists down a number of corrupt practices as you can see in this list. It also mentioned about the punishment if a person was supposed to be alleged in corrupt practices. It says that any person who in connection with an election under this act promotes or attempts to promote on grounds of religion, race, caste, community, language, feelings of enmity or hatred between different classes of citizens of India shall be punishable with imprisonment for a term which may extend to 3 years or with fine or with both. So we understand that conviction can be in two ways. First of all, it can be in the terms of fine, and second, it can be in the terms of imprisonment or jail term. And this disqualification will only trigger when a MP or a MLA has been convicted either with fine or with imprisonment as per the law. Now, with respect to disqualification of Sikkim, this topic was covered in the 2019 October edition of Focus magazine, where it said that the Sikkim Chief Minister was barred from contesting elections for 6 years after completion of 1 year prison term for corruption in 2018. So the CM of Sikkim was convicted with respect to corruption in 2018 and accordingly he was barred for 6 years as per the law. However, the Election Commission of India granted a reprieve, that is, he was let off by the Election Commission of India as the Commission reduced the disqualification period to just 1 year and 1 month. And accordingly, after this particular order of the Election Commission, the CM of Sikkim was eligible to contest elections. Again, we mentioned about Section 81M, which mentioned that a person convicted of an offence punishable under Prevention of Corruption Act shall be disqualified to contest elections for a further period of 6 years since his release, that is, after his release. And it is in this aspect where the power of Election Commission under Section 11 of Representation of People Act become equally important, as it allows the Election Commission to either reduce the duration of the conviction or to remove the disqualification completely. So while writing your answer with respect to grounds of disqualification, corrupt practice can be mentioned as one of the grounds, and it includes the following aspects, that is bribery, undue influence, direct or indirect interference in election by the candidate or his agent, appeal by a candidate on grounds of race, caste, community or language, or even on religious symbols, or appeal to national symbols. Further, if the person attempts to promote feelings of enmity or hatred between different classes of communities or citizens on grounds of religion, race, caste, community, language, etc., either on the propagation or practice of sati or its glorification for election prospects, for publication of any false statements about rival candidates, as well as getting any assistance from any gazetted officer to enhance electoral prospects. So, for all these, the disqualification shall not exceed 6 years from the date on which the order takes effect. So, this again becomes another important aspect, that is, the maximum period of disqualification becomes 6 years. Other grounds of disqualifications are disqualification for dismissal for corruption or disloyalty. So, if a person who has held any office under the Indian government or state government is either dismissed for corruption or for disloyalty, then such person shall be disqualified for a period of 5 years from the date of such dismissal. That is, such a person who has been convicted for corruption or disloyalty cannot contest election for another period of 5 years. And if a case is pending against such person who is already a MP or a MLA and he has been convicted under corruption or disloyalty, then such person shall also be disqualified. Another grounds is that disqualification for having government contracts. So suppose if a person has entered into a government contract with respect to any trade or business or with respect to any supply of goods, so that particular person during the course of the contract cannot contest election. And if a person is already a MP or a MLA and it is proved during a course of investigation that he has entered into government contracts with respect to any trade or business, then such will also act as a ground for disqualification for such MP or MLA. Moving further, two another important aspects of grounds of disqualifications are failure to lodge account of election expenses and disqualification for office under government company. It says that if the election commission is satisfied that a person has failed to lodge an account of election expenses within the time and the manner required as per this act, or has no good reason or justification for the failure with respect to failure of lodging election expenses. So basically, if a candidate who has been elected as MP or MLA and he did not file his election expenses, then that amounts to a ground of disqualification. It says that the election commission shall declare him to be disqualified, and any such person shall be disqualified for a period of 3 years from the date of that particular order. Now, if a person is a MP or a MLA and at the same time he is also holding any office whereby he is a managing agent, manager, or secretary of any company or corporation of the Indian government, then in such situation it will amount to disqualification of that MP or a MLA. However, this will not include any cooperative society. So, if a person is either a managing agent, manager, or secretary of any company or corporation of the Indian government in which the government has not less than 25% share. So, basically, if a company whereby the government has 25% share or more, then such managing agent, manager, or secretary cannot become MP or MLA during the time in which such person is already the managing agent, manager, or secretary of such government company whereby the government has share of 25% or more. So all these can be said to be grounds of disqualification. Now, with respect to disqualification of a representative of people, there are three different aspects. The first is with respect to disqualification which has taken place after the person has become MP or a MLA. Second, any prior criminal case has been pending against such person who has been elected as MP or MLA. And the third aspect is that such cases of disqualification has been filed as a result of an election petition under section 80 as well as 80A with respect to the High Court, or such petition has been filed to the High Court under Representation of People Act of 1951. So these are the three different scenarios. Now, with respect to any prior criminal case pending in a court of law, or in any case with respect to election petition filed in a high court with respect to disqualification, then such decision of the high court which finds any representative of people guilty of corrupt practice or guilty with respect to any grounds of disqualification, then such decision with respect to disqualification shall be submitted to the President of India by the central government. Now, before giving any decision, the President of India shall consult the Election Commission, and the provision says that the President has to act mandatorily as per the opinion given by Election Commission with respect to disqualification of any particular candidate or of any MP or MLA. So these are the different aspects with respect to disqualification. Now coming to the remedy, So, either the person who has been disqualified can either appeal to the election commission, as we saw in the case of Chief Minister of Sikkim, or if the decision has been given through an election petition or through any prior criminal case by the High Court or the Supreme Court, then with respect to decision of the High Court, the appeal shall lie to the Supreme Court. Now, there are two important provisions with respect to communication of orders of the High Court and also with respect to appeals to Supreme Court. Now, Section 103 and 116A has been taken from Representation of People Act of 1951. Section 103 says that the High Court shall, as soon as may be, after the conclusion of the trial of an election petition, intimate the substance of the decision to the election commission. Basically, tell the election commission that what has been decided by the High Court with respect to an election petition. And accordingly, the Speaker or Chairman of House of Parliament or that of state legislature concerned, as soon as possible, shall send to the election commission about this particular decision of the High Court. So this is one aspect with respect to communication of the decision of the High Court to the Election Commission of India. The next part is with respect to appeals to Supreme Court. It says that an appeal shall lie to the Supreme Court on any question of law or fact from every order made by a High Court under Section 98 or 99. That is basically with respect to any of the decision of the High Court with respect to an election petition. And accordingly, it says that every appeal to the Supreme Court shall be preferred within a period of 30 days from the date of the order of the High Court under Section 98 or 99. So, if a candidate is disqualified through an election petition, then one remedy is that he can appeal to the Supreme Court. And second aspect is that he can directly appeal to the Election Commission under Section 11 of the Representation of People Act, as the Election Commission has power either to reduce the duration of disqualification or to remove it completely. Now, this aspect of Election Commission was also covered in the June 2019 edition of Focus magazine, where we mentioned different aspects with respect to disputes during an election commission. So, with respect to remedy, we can mention 2 points. That is, first, an appeal can be directly made to the election commission, and secondly, if it is a case of election petition or with respect to any decision of High Court, an appeal can be made in the Supreme Court. Thus, after a discussion with respect to various aspects of this particular question, let us go through the sample answer. As mentioned, you can introduce your answer with respect to Article 327 of the Indian Constitution, as it says that this article empowers the Parliament to make law about elections and disqualification of legislatures, and accordingly, the RPA 1951 provides for grounds of disqualification of MPs and MLAs. Then you can write about various grounds of disqualifications which we have discussed. And finally, coming to remedies, you can say that the person can approach the Election Commission for waiver, or if the disqualification has resulted due to an election petition filed in High Court, then the person can approach Supreme Court for appeal under Section 116A of Representation of People Act. And after writing both the grounds of disqualification and remedies available, you can straight away come to the conclusion part, where you can say that a person is disqualified only after conviction of their offence. And in this regard, the government must implement the recommendations of 244th Law Commission report pertaining to decriminalization of politics, whereby even the Law Commission agreed that the electoral disqualification of a person must initiate at the stage of framing of charges with adequate legal safeguards, so as to have a cleaner politics and remove persons having criminal backgrounds. So you can conclude this particular answer on this particular note with respect to recommendations of Law Commission of India. So in this discussion, this can be said to be your sample answer with respect to the question asked on grounds of disqualification as well as with respect to remedies available.